The clerk stopped mid-sentence. Paper shifted once across the wooden desk, then settled. No one reacted at first. Probate hearings move slowly. Pauses are common, pages turn, files close, names are mispronounced. But this pause held. The probate file in front of the judge was thick, 212 pages secured with 2 metal fasteners. I knew the count because I had reviewed a copy 3 nights earlier at 11:40 p.m. Across the aisle, my brother Daniel leaned back in his chair, one arm resting across the empty seat beside him. His attorney, Mark Halpern, had arranged 3 folders in a clean horizontal line: estate summary, medical documentation, power of attorney. The estate totaled $1,284,600 at the time of filing. The lake house alone carried an assessed value of $487,000. The primary investment account showed $214,600 as of February 28th. 3 certificates of deposit combined for $162,000. A commercial property on Westbridge generated $8,400 per month. The checking account balance on April 2 was $73,480. Those numbers had been repeated twice already that morning. "Your Honor," Halpern said calmly, "as the record reflects, the family acted in a measured and responsible manner once cognitive decline became evident." The word decline was not emphasized. It was delivered neutrally. Daniel nodded once, as if confirming something obvious. I remained seated at the opposite table, no attorney beside me. When the clerk resumed speaking, he addressed Halpern, not me. "Counsel, the notarized power of attorney is on page 143. A copy was slid across the polished surface, toward Halpern. I waited for one to be extended in my direction. It wasn't. After a moment, I reached for the court's shared copy instead. Halpern glanced at the movement, then back at the judge. "She's always had difficulty keeping complex timelines straight," Daniel said quietly. "Not to me, not even directly to the judge, just into the room." The judge did not respond to that. Instead, he turned 1 page back in the file. "And the execution date was March 19? He asked. "Yes, Your Honor," Halpern replied. "Properly witnessed and notarized at 3:42 p.m. The timestamp was printed clearly beneath the signature. Notary ID number included. Linda, seated 2 chairs behind Daniel, folded her hands over a dark leather purse. Her posture was composed, measured. "She was overwhelmed," she added softly. "We were trying to protect stability." Protect. Stability. The estate's commercial property had not missed a rent payment in 17 years. The clerk adjusted his glasses again and traced a line with his finger. "There is a cognitive evaluation summary earlier in the record," he said. Halpern nodded. "Yes, conducted mid-March." The judge located the page. 18 out of 30, he read. "Mild impairment," Halpern clarified smoothly. No one explained what 18 indicated. No one needed to. Daniel shifted slightly in his seat. She called the bank 3 separate times questioning authorized withdrawals, March 24, March 28th, and April 1. It created unnecessary confusion. Those dates were accurate, so were the withdrawals. 6 wire transfers under $10,000 had been initiated over an 11-day span. The total was $82,400. The judge turned back to the notarized document. "Help me understand the sequence here," he said evenly. "The power of attorney was signed March 19 at 3:42 p.m. "Yes, and the hospital intake form in this record is dated March 19 as well." The clerk nodded. Daniel's confidence did not disappear, it narrowed. "That was the same week," Halpern replied carefully. The judge did not look up. "What time was intake?" The clerk scanned the line again. 2:55 p.m. A brief silence followed. "And medication administration?" the judge asked, still studying the page rather than the people in front of him. The clerk cleared his throat once. "Sedation recorded at 3:10 p.m. No one spoke immediately after that. Daniel's pen, which had been tapping lightly against the table earlier, stopped. Halpern flipped back to the notarization page. "Your Honor, it's possible." The judge raised his hand slightly, not to silence him, but to pause the pacing. "I'm simply reviewing the timeline," he said. The fluorescent lights hummed faintly overhead. The clerk shifted a page corner. "Discharge is documented as March 21, 2 days after execution." Daniel's posture changed subtly. He leaned forward now, elbows on the table. There were multiple consultations that week. Everything moved quickly. The judge nodded, once, still neutral. "And at 3:42 p.m., he repeated quietly, eyes on the notarized signature, "this document was executed." "Yes." The room remained composed. No raised voices, no visible alarm, but the narrative that had felt settled 30 minutes earlier was no longer as smooth. Halpern adjusted his tie. The family acted prudently, given the evaluation. The judge turned one page backward again to the cognitive score, 18 out of 30, then forward again to the power of attorney timestamp, 3:42 p.m., then back to intake, 2:55 p.m., then medication, 3:10 p.m. He did not look at me. He did not look at Daniel. He looked at the paper. Daniel inhaled slowly. "She's misinterpreting events. That's been the issue from the beginning." No one had asked him that. The judge closed the file halfway, leaving his finger marking the notarized page. "I'd like clarification regarding capacity at the precise time of execution," he said evenly. "Not an accusation, a request." Halpern nodded quickly. "Of course." Linda shifted in her seat for the first time. The clerk began making a note in the margin. I did not speak. I did not need to. The timestamps were already in the record. The judge reopened the file fully. "We'll pause here," he said. "No ruling, no conclusion, just a pause." And for the first time that morning, Daniel was no longer leaning back. "I was removed from the medical contact list on March 22. No one informed me directly. I discovered it when the nurse at St. Andrews asked me to verify my authorization code and then paused. "I'm sorry," she said, "you're no longer listed." The update had been processed at 9:14 a.m. that morning. The power of attorney had been scanned into the hospital system at 8:52 a.m. I wrote both times down. Daniel handled most conversations after that. He used phrases like continuity of care and reduced stress exposure. The language sounded administrative, not personal. Linda began answering my questions with summaries instead of specifics. "The doctors are monitoring him. The bank accounts are stable. There's nothing you need to worry about." On March 24, when I called Westbridge Commercial Bank to question a transfer of $9,800, the representative confirmed it had been authorized under the newly recorded power of attorney. The authorization time listed was 11:06 a.m. I asked for the destination account. They declined to provide it without executor verification. I called again on March 28 regarding a second transfer, $9,600. Then April 1, $9,750. By April 4, 6 transfers had been initiated. None exceeded $10,000. The cumulative total reached $82,400. When I mentioned the pattern, Daniel sighed. "You're reading into normal liquidity adjustments," he said. "This is exactly what we meant." "What you meant?" I asked. "That you get overwhelmed by fragments." Fragments? On March 30, the investment portfolio allocation changed. The $214,600 position in municipal bonds was partially liquidated. $47,200 moved into a short-term holding account. The transaction reference listed Daniel as acting agent. I requested a duplicate confirmation statement from the brokerage office. The representative hesitated. "I'm seeing updated control authority," she said carefully. "Yes," I replied. "I see that too." She did not send the statement. The commercial property continued generating $8,400 per month, but the April rent was redirected into a newly opened operating account ending in 4421. The account had been established on March 23 at 3:18 p.m. Daniel's explanation was consistent: consolidation, efficiency, temporary structure. Linda's explanations were softer: you don't need to track every movement. On April 2, I visited the hospital records department in person. The full file required a signed request form and a $38 duplication fee. The printed file totaled 146 pages. I reviewed it that night. Intake: March 19, 2:55 p.m. Cognitive assessment score: 18 out of 30. Sedation administered 3:10 p.m. Observation notes continued through March 20th. Discharge finalized March 21 at 10:32 a.m. There were no physician notes documenting restored capacity on March 19 after 3:10 p.m. I highlighted nothing. I simply inserted page tabs. On April 6, Daniel emailed a draft estate management outline. The document estimated annual maintenance expenses for the lake house at $26,400. It proposed listing the property within 90 days. Projected sale price, $495,000. Given current conditions, he wrote, this is fiscally responsible. I responded once. Has the court approved executor transition? There was no reply for 2 days. Instead, on April 8th, I received a certified letter from Halpern's office stating that all inquiries regarding estate management should be directed through counsel to avoid administrative interference. Interference. The letter referenced the March 19 power of attorney as controlling authority. On April 10, I visited Westbridge Commercial Bank in person. The branch manager confirmed that the checking account balance had declined from $73,480 to $41,062 over a period of 12 days. Authorized withdrawals, operational adjustments. When I asked for printed transaction logs, he provided summaries, but not internal memos. The acting agent has discretion, he said. I noted the phrasing. On April 12th, Daniel forwarded a calendar invitation titled Property Evaluation, April 18, 2 p.m. Location: Lake House. I had not been consulted about scheduling. When I asked whether probate approval had been finalized, he responded, court proceedings are procedural. This is preventative planning. Preventative. On April 14, I reviewed the notarization registry online. The notary ID listed on the March 19 document corresponded to an office located 11.4 miles from the hospital. Operating hours, 9 a.m. to 5 p.m. Appointment required after 3 p.m. I wrote down the address. On April 16, Halpern filed a supplemental memorandum asserting that family consensus supported Daniel's appointment as executor. The filing referenced documented confusion exhibited by Miss Carter during multiple financial discussions in late March. No examples were attached, no transcripts were included. On April 10, the property evaluation proceeded without me. The real estate agent's listing draft circulated internally the following morning. Suggested photography date, April 27th. Projected closing window, 45 to 60 days post-listing. I requested copies of the appraisal inputs. The Halpern's office declined, citing active authority control. On April 20, I assembled a single spreadsheet. Column A, date. Column B, time. Column C, event. Column D, source document page number. March 19, 2:55 p.m., hospital intake, page 12. March 19, 3:10 p.m., sedation, page 14. March 19, 3:42 p.m., power of attorney execution, page 143. March 21, 10:32 a.m., discharge, page 22. March 23, 3:18 p.m., new operating account opened, bank log. March 24 through April 4, 6 transfers, bank summary. I did not send the spreadsheet to anyone. On April 22, Daniel called. "You're creating unnecessary friction," he said. "The court will see that. The court will see dates." There was a pause. "You're misunderstanding the sequence again." Sequence. On April 24, I submitted a formal request for complete notary session records from March 19, including witness logs and identification entries. The response time listed on the website was 7 to 10 business days. The probate hearing was scheduled for May 3. Daniel sounded certain when he told Linda, within my hearing range in the courthouse hallway, "It's procedural. She won't be able to untangle it." I wrote that down too. By April 28, the checking account balance had declined further to $33,906. No asset freeze had been issued. No executor confirmation had been finalized. Everything was still temporary. On April 1, the notary registry confirmed my request for receipt. Status: processing. I printed the confirmation page. On April 2 at 6:14 p.m., I placed the hospital file, bank summaries, and my spreadsheet into a single binder. I did not annotate it. I closed it. The next morning, the clerk would call the case again, and the record would still show March 19 at 3:42 p.m. The hospital file arrived in a plain brown envelope, stamped Records Release, 146 pages. I signed for it at 9:12 a.m. I did not open it in the parking lot. I waited until I was home, cleared the dining table, and set my laptop to the right of the stack. The top sheet listed my father's intake, March 14th, 2:55 p.m. Admitting physician, Dr. Hannah Lowell. Reason: cognitive disorientation, reported memory lapses, medication review requested. His cognitive score was printed in bold on page 3, 18/30. No commentary, just the number and the scale beneath it. On March 19th, 5 days later, the power of attorney was executed. I already knew the date. It had been repeated in court, stated casually as if it were ordinary. March 19th. I created a spreadsheet that afternoon. Column A, date. Column B, time. Column C, event. Column D, source. I entered March 14th, 2:55 p.m. Hospital intake. Source, page 1. Then, 3:10 p.m., sedation administered. Source, medication log, page 7. The dosage was 2 milligrams lorazepam intravenous. I entered March 15th through March 18th line by line. Vitals, observations, a note on March 17th. Patient demonstrates confusion regarding financial matters. No interpretation attached, just the sentence. On March 19th, there were 3 entries. 2:55 p.m., follow-up evaluation. 3:10 p.m., sedation administered. 3:42 p.m., document notarized. The notary stamp was visible on the copy filed with the court. Commission ID 44721. County, Jefferson. Expiration, August 2027. Time, clearly printed beneath the seal, 3:42 p.m. I opened the state notary registry at 7:48 p.m. and searched the commission number. Active. Office address matched the footer of the power of attorney. I added a new column, location. Intake, St. Andrew's Medical Center. Notary office address, 214 West Briar Avenue, Suite 300. Travel time between them at that hour, 18 minutes without traffic. Sedation was administered at 3:10 p.m. The notarization was stamped at 3:42 p.m. I did not calculate the gap out loud. I added March 21 to the spreadsheet, discharge date, 2 days after the power of attorney was signed. He was still admitted when it was executed. I printed the medication log in grayscale and placed it beside the notarized document. The signature line on the power of attorney was steady, clean, full name written without tremor. On March 18th, a nurse had documented, patient requires assistance recalling date and location. On March 19th at 2:55 p.m., the follow-up note stated, cognitive impairment persists, recommend supervision regarding legal decisions. The recommendation was not crossed out. I highlighted nothing. I scanned the bank summaries next. 6 wire transfers between March 22nd and April 3rd. each one under $10,000, $9,800, $9,750, $9,920, $9,640, $9,880, $9,700. Total, $58,690. Combined with the earlier $23,710 withdrawal on March 20th, the movement totaled $82,400 within 15 days. I added another sheet labeled Transfers. My brother, Ethan, had listed the lake house for $487,000 on April 9th. The investment account, valued at $214,600, had been partially liquidated on April 11th. All actions followed March 19th. The power of attorney was the hinge. I reviewed the hospital visitor log. March 19th showed one entry at 4:10 p.m., Ethan Carter. Duration, 37 minutes. No additional visitor sign-in recorded before 4 p.m. The notary acknowledgement did not list witnesses by name. It stated, "Signed in my presence." I searched the county clerk filings for similar formatting. The template matched standard digital acknowledgement formatting used by mobile notary services. Mobile. I added a final column, mobility. If sedation was administered at 3:10 p.m. and the notarization occurred at 3:42 p.m., the notary would have to be present at the hospital. The document listed no hospital address. It listed Suite 300. I checked the metadata of the scanned PDF filed with probate court. Created March 19th at 4:08 p.m. Modified 4:16 p.m. I saved a copy. At 10:14 p.m., I printed an enlarged version of the signature page, 125% scale. The timestamp beneath the seal was clearer that way. The 3 in 342 had a slight ink spread on the lower curve. I placed the enlarged copy into a separate folder. Ethan called at 10:32 p.m. I let it go to voicemail. His message was 18 seconds long. He mentioned the court date and said the process was almost wrapped. His tone was relaxed. I updated the spreadsheet one more time before midnight. March 14th, 2:55 p.m. Intake. March 19th, 2:55 p.m. Evaluation. March 19th, 3:10 p.m. Sedation. March 19th, 3:42 p.m. Notarization. March 21, discharge. The sequence did not require commentary. On March 19th, according to the medication log, my father was described as drowsy but responsive at 3:25 p.m. 17 minutes later, he executed a durable power of attorney, transferring full financial authority to Ethan. I closed the laptop at 12:03 a.m. The next morning, I requested certified copies of 3 documents: the cognitive assessment dated March 14th, the follow-up evaluation dated March 19th, and the medication administration record covering 2 p.m. to 4 p.m. on March 19th. The clerk at St. Andrews said processing would take 3 business days. I marked the calendar. Ethan texted at 1:17 p.m. the following day. We should finalize the lake house listing by Friday. Friday was April 12th. I did not respond. Instead, I reviewed the probate filing again. The attorney had referenced medical clearance prior to execution. The phrase appeared on page 6 of the motion. There was no clearance form in the 146 pages, only evaluation notes, and a score, 18/30. I added one more line to the spreadsheet. March 19th, no documented capacity clearance. Then I sorted the sheet by time. Everything aligned except one detail, the power of attorney. I placed the enlarged copy on top of the hospital timeline and secured them both with a binder clip. I did not feel urgency. I felt sequence. On April 2nd, I ordered a bound presentation folder, navy blue, 1-inch spine. It arrived on April 5th. I inserted tabs labeled Intake, Evaluation, Medication, Notary, Transfers. 5 sections. By April 8th, the certificate copies had arrived, raised seal visible, dates intact. I compared the certified March 19th evaluation time to the notarization again, 2:55 p.m., 3:42 p.m., 47 minutes. I closed the folder and placed it in my briefcase. The next hearing was scheduled for 9:30 a.m. on April 18th. I checked the travel time to the courthouse, 22 minutes from my apartment. I planned to arrive at 8:59. Ethan believed the estate was already settled. The attorney believed the documentation was routine. The court believed the power of attorney was valid. I reviewed the date one last time before turning off the light. March 19. They had said I was confused about the sequence. I wasn't. I was arranging it. The judge did not look at me when she asked for the medical file. She looked at Ethan's attorney. Counsel, was Mr. Carter under cognitive evaluation on March 19th? The question settled into the room without volume. We were back in probate court at 9:34 a.m. The clerk had just resumed reading the estate inventory. $1.2 million total valuation. $487,000 lake house. $214,600 investment account. The numbers sounded orderly. Ethan sat straight, hands folded. Marlene kept her expression neutral. Their attorney, Daniel Reeves, had a yellow legal pad open in front of him. He adjusted his glasses. Your Honor, Mr. Carter had been seen for mild memory concerns earlier that week, but he was competent at the time of execution. The judge lowered her pen. At the time of execution, she repeated, which was 3:42 p.m. March 19th, correct? Yes, Your Honor. I opened my briefcase and placed the navy folder on the table. The judge's gaze shifted briefly, then back to Mr. Reeves. And the evaluation that week, she said, that would be March 14th? Yes. She paused. And was there a follow-up on March 19th at 2:55 p.m.? There was a silence long enough for the clerk to stop typing. Mr. Reeves glanced at Ethan. It was subtle. Ethan's jaw tightened for less than a second. I would need to review the hospital records to confirm specific times, Mr. Reeves said. I have them, I said. My voice did not carry far. It did not need to. The judge looked at me directly for the first time that morning. You have certified copies? Yes, Your Honor. She extended her hand slightly. Approach. I stood, walked the 12 steps to the bench, and handed the folder to the clerk. Tabs were visible along the right side. Intake, evaluation, medication, notary, transfers. The judge opened to the second tab first. March 19th, she read quietly, 2:55 p.m. Follow-up evaluation, cognitive impairment persists. Recommend supervision regarding legal decisions. She turned a page. Medication administration log, 3:10 p.m. Lorazepam, 2 milligrams intravenous. The courtroom was still. She flipped to the notary tab. Power of attorney executed March 19th at 3:42 p.m. She did not raise her voice when she read the time. She looked back at Mr. Reeves. Was Mr. Carter discharged before or after March 19th? After, Your Honor. Specifically, March 21. She closed the folder halfway. So, to clarify, Mr. Carter was admitted to St. Andrew's Medical Center on March 14th at 2:55 p.m., received a cognitive score of 18 out of 30, underwent a follow-up evaluation at 2:55 p.m. on March 19th, was administered sedation at 3:10 p.m., and executed a durable power of attorney at 3:42 p.m. the same day. He was discharged 2 days later. No one corrected her. Ethan shifted in his seat. Mr. Reeves cleared his throat. Your Honor, sedation does not necessarily invalidate capacity. Patients can remain oriented. The judge nodded once. Agreed, which is why I'm asking about medical clearance. She turned back to the evaluation tab. I do not see a capacity clearance note, do you? Mr. Reeves stood. The attending physician believed. I'm not asking what was believed. I'm asking what was documented. He did not answer immediately. The judge looked at the clerk. Mark these as Exhibit D4. The clerk stamped the corner of the first page. The sound was sharp. Was the notary physically present at the hospital? The judge asked. Mr. Reeves glanced at the power of attorney copy. The document lists Suite 300, 214 West Briar Avenue. That is not a hospital address, the judge said. No, Your Honor. She leaned back slightly. So either the notary traveled to the hospital and used an office address, or Mr. Carter traveled to Suite 300 at some point between 3:10 p.m. and 3:42 p.m. after sedation. The courtroom remained quiet. Travel time between the hospital and West Briar Avenue was not entered into evidence. It did not need to be. Ethan's earlier confidence had thinned. He looked at his attorney instead of the bench. Marlene kept her hands folded. The judge opened the transfers tab. 6 wire transfers under $10,000 between March 22nd and April 3rd, totaling $58,690, plus a withdrawal of $23,710 on March 20th. She looked up. These occurred under the authority of this power of attorney. Yes, Your Honor, Mr. Reeves said. She closed the folder fully. Given the proximity of the medical evaluation, the sedation record, and the execution timestamp, the court has concerns regarding capacity at the time this document was signed. She did not raise her voice. Accordingly, I am ordering a temporary suspension of all asset transfers under the March 19th power of attorney, pending formal review. The clerk stopped typing for half a second, then resumed. Clerk, continued the judge, issue notice to the financial institutions holding the $214,600 investment account and any related accounts, effective immediately, no further transfers without court authorization. Ethan inhaled sharply. This is procedural, the judge said calmly, not punitive. She turned to Mr. Reeves again. You will provide within 7 days any documentation supporting a finding of capacity at 3:42 p.m. on March 19th. If none exists, this court will consider invalidating the instrument. Invalidating. The word was not emphasized. It did not need emphasis. Mr. Reeves nodded once. Understood, Your Honor. The judge looked at me again. Miss Carter, ensure the certified copies are filed with the clerk before close of business today. Yes, Your Honor. She tapped her pen lightly against the bench. Court will reconvene April 25th at 10 a.m. for evidentiary review. The gavel did not strike hard. It struck once. As people began to stand, Ethan leaned to his attorney and spoke in a low voice. I did not try to hear the words. Marlene's posture had shifted, less certain, more measured. The clerk handed my folder back to me after marking each exhibit. The raised seal on the March 19th evaluation was visible under the fluorescent lights. 2:55 p.m., 3:10 p.m., 3:42 p.m. Outside the courtroom, the hallway noise resumed. Quiet conversations, shoes against tile, elevator chimes. Ethan approached me halfway to the exit. This is unnecessary, he said evenly. Dad wanted stability. I adjusted the folder under my arm. The record reflects what it reflects. He did not respond. At 10:18 a.m., I stepped outside the courthouse. My phone vibrated once. Email notification from Jefferson County probate clerk. Asset freeze. Notice. Issued. I did not open it immediately. The suspension was temporary. The review was scheduled. The document remained under question. Inside the courtroom, it had taken less than 11 minutes for the tone to change. No one had raised their voice. No one had argued. The date had been read aloud, and the room had adjusted around it. The judge did not begin the April 25 hearing with introductions. She began with a question. Counsel, do you have documentation establishing capacity at 3:42 p.m. on March 19? The courtroom was quieter than before. Fewer observers. Same clerk, same bench, same file. Mr. Reeves stood slowly. Your Honor, after reviewing the hospital records, we acknowledge there is no separate written clearance issued between the 2:55 p.m. evaluation and the execution of the power of attorney. The judge nodded once. And the attending physician? Provided a supplemental letter dated April 18, he said, sliding a document forward. It states that sedation does not automatically negate legal capacity. The judge read it without expression. The letter was 3 paragraphs, no timestamp reference, no addendum to the original March 19 chart, no statement that the physician assessed capacity after 3:10 p.m. She placed it on the bench. The court is not evaluating sedation in theory, she said. The court is evaluating documented capacity at a specific time. She opened the certified evaluation again. March 19, 2:55 p.m. Cognitive impairment persists. Recommend supervision regarding legal decisions. She turned a page. 3:10 p.m. Lorazepam administered intravenously. She looked at Ethan. Was there any independent witness present at execution? Mr. Reeves answered, No, Your Honor, only the notary. And the notary acknowledgement lists Suite 300, 214 West Briar Avenue, not St. Andrew's Medical Center. That is correct. The judge folded her hands. The record reflects that Mr. Carter was admitted March 14 at 2:55 p.m., assigned a cognitive score of 18 out of 30, remained admitted through March 21, and executed a durable power of attorney at 3:42 p.m. on March 19, 32 minutes after documented sedation. She paused briefly. Absent contemporaneous documentation of restored capacity, the instrument cannot stand. No one interrupted her. Accordingly, she continued, the March 19 power of attorney is declared invalid. The words were even, procedural. The clerk typed without hesitation. Ethan did not look at me. Marlene's hands tightened slightly around her purse strap. The judge continued, all financial authority exercised under the invalidated instrument is subject to review. This court orders a forensic audit of transactions conducted between March 19 and April 18. She looked toward the clerk. Appoint an independent fiduciary, effective immediately. The name was read aloud. Thomas Whitaker, court-certified fiduciary. Mr. Whitaker will assume temporary control of estate accounts, pending completion of audit and redistribution proceedings. Mr. Reeves made a small motion as if to speak, then stopped. The 6 wire transfers totaling $58,690 and the March 20 withdrawal of $23,710 are to be traced and reconciled, the judge added. Any funds not demonstrably used for the direct benefit of Mr. Carter shall be returned to the estate. Ethan inhaled slowly. The judge turned another page. The lake house, listed at $487,000, is not to be sold until final determination of executor appointment. She looked at me. Ms. Carter, you petitioned for review, but did not petition for executor reassignment. Do you wish to amend? Yes, Your Honor. My voice carried steadily. File the amendment by 4 p.m. today, she said. Given the findings, the court is inclined to remove Ethan Carter as acting trustee pending final order. No reaction from Ethan, only stillness. The hearing lasted 41 minutes. When it concluded, the gavel struck once. Outside the courtroom, Mr. Whitaker introduced himself. Mid-50s, gray suit, direct handshake. I'll need full access to your documentation, he said. You'll have it by noon, I replied. At 11:42 a.m., I emailed a secured folder containing the timeline spreadsheet, certified evaluations, medication logs, transfer summaries, and notary registry confirmation. At 2:18 p.m., Mr. Whitaker confirmed receipt. The audit began April 26th. By May 3rd, preliminary findings were issued. Of the $82,400 moved between March 20 and April 3rd, $31,200 had been transferred into an account ending in 4407. $27,850 had been used toward a private consulting retainer in Ethan's name. $9,640 had been categorized as property preparation. $13,710 remained unaccounted for pending documentation. On May 8th, Mr. Whitaker requested reimbursement of $96,000 to reconcile discrepancies and projected penalties. Ethan complied on May 14th. Funds were wired back into the estate account at 10:06 a.m. The confirmation notice arrived at 10:11 a.m. On May 22nd, the court reconvened for final disposition. The judge reviewed the audit summary. All disputed transfers have been restored. No further discrepancies remain, she said. She looked at Ethan. The court finds that the March 19 instrument was executed while Mr. Carter was under documented cognitive impairment and without contemporaneous medical clearance. She turned to the clerk. Remove Ethan Carter as acting trustee effective immediately. There was no objection. Appoint Ms. Carter as executor under supervised administration. The clerk entered the order. The estate valuation remained $1,187,940 after adjustments and recovered funds. The investment account stood at $214,600. The lake house listing was withdrawn at 3:12 p.m. that afternoon. Marlene did not speak during the hearing. When it ended, the judge delivered a final statement. The record reflects incapacity at the time of execution. Legal authority requires clarity, not assumption. She closed the file. No one apologized. No one addressed me directly. There was no confrontation in the hallway, only quiet rearrangement. On June 4th, I met with Mr. Whitaker to review final paperwork, 11 signatures, 3 notarized acknowledgments, 2 banking confirmations. Each document contained timestamps. I reviewed every one. On June 11th, the executor bond was approved. On June 18th, I authorized payment of outstanding medical bills totaling $48,550. Hospital charges dated March 14 through March 21 were settled in full. The estate account balance adjusted accordingly. By July 2nd, distribution planning was underway under court supervision. Nothing dramatic happened. No raised voices, no declarations, just documentation. Ethan did not contact me after May 22nd. The word confused did not appear in any order issued by the court. It did appear once in the March 17 nurse's note. Patient demonstrates confusion regarding financial matters. That note remained part of the official record. The power of attorney dated March 19 did not. It was archived as invalid. On June 15th, I visited the lake house alone. The listing had been removed for 86 days. The water level was lower than it had been in April. I walked through each room with a clipboard, documenting condition reports, 14 photographs, 6 maintenance notes, 1 repair estimate of $12,480 for duct stabilization. Preparation. At 4:48 p.m., I locked the door and drove back to the city. There were no conversations left to have, only management. On August 3rd, the final probate order was entered. Estate settled under supervised administration. Executor confirmed. Audit closed. The process had taken 142 days from the March 14 intake. The difference between 2:55 p.m. and 3:42 p.m. determined all of it. No one mentioned that gap again in court. It did not require repetition. When I reviewed the full file one last time, the tabs remained in the same order: intake, evaluation, medication, notary, transfers. 5 sections, 5 steps. Silence was not confusion. Documentation was not emotion. Dates had not argued. They had simply existed. They thought I was too confused to inherit. I was counting.